Thank you so much, Alexandra. And the next speaker is Mark Osiel. Mark Osiel was introduced at the previous panel, but there are new visitors in the room, so I should say a few words. Mark Osiel is one of those people who have both a PhD in sociology and a law degree. He earned those at Harvard University. He is now on the law faculty at the University of Iowa, so he's a southern neighbor of mine, which is an honor to me. He describes, he has a fascinating brief statement. I have to read this one line in this little bio blurb. And it says he employs social historical explanation to inform our normative assessment of those responsible for genocide, war crimes, etc. So we think of these as distinct categories, explanation and then normative assessment, right? And here is someone who tries to tie them together. That's in line with your dual degree, of course. And this the dual degree is reflected in his fantastic books. The book Mass Atrocity, Collective Memory and Law was one that really attuned me to this theme, so I owe you a great deal. You have written 6 additional books and 2 are forthcoming. One I will mention, After Atrocity, New Approaches to the Restraint and Redress of Mass Killing, which will be coming out with Cambridge University Press. Mark, it is good to have you here.
Thank you so much, Joachim. You claim that my introduction of you is overly generous, but this is overly, excessively generous. I want to talk about Latin America today and leave it primarily to you all to decide, to determine how relevant this actually is to the Latin American experience, to the Central and East European one. It may be in Latin America that Latin America has seen the most self-conscious efforts in recent years to employ law to alter collective or public memory of mass atrocity, not as a byproduct of other policies, but as a self-conscious goal in itself. Over the last 15 years, the Inter-American Court of Human Rights has rendered many judgments in response to mass atrocities throughout the region. The court describes all these measures as legal remedies for past wrongs, not policies of transitional justice, which are more prospective than retrospective in focus. Since these remedies are partly designed to influence memory, the question is whether that's a legitimate role for courts and how they fit with accepted understandings of what judicial remedies are for, how they work. Nowhere else in the world, though, have courts taken these steps. Now, on the standard theory, as I'll call it, judicial remedies aim only to put the plaintiff, victim, into the position she would have occupied but for the defendant's wrong. That's often called making the plaintiff whole, or simply the rightful position. Sometimes this requires peering back into a time where the victim stood before the wrong, the status quo ante. Sometimes it demands that we try to imagine where the plaintiff would have stood in the future if the defendant had not harmed her. The scope of the remedy, in either case, follows directly from the scope of the legal wrong, which flows in turn naturally from the scope of the legal right that's been breached. This requires separating out the harm done by the defendant's unlawful conduct in the case at hand on the specific facts before the court from any wider context. Granting the plaintiff more than his rightful position makes the defendant accountable for harms it has not caused, or hasn't been legally proven to have caused. So, for the Inter-American Court, we have to ask, what's the connection exactly between what the victims are shown to have suffered at the state's hands and what the court orders, often in very far-reaching institutional and even cultural change? The immediate victims of the wrong, those before the court, are often a small number of people, while the intended beneficiaries of the ensuing remedies are a much larger class, effectively society at large, though the plaintiffs are not formally certified as a class, as they would have to be in the United States at least, to get such broad relief. And on what legal authority is the court adopting such ambitious goals? The court's decisions themselves say shockingly little about this, nor does the scholarly commentator, which is essentially cheerleading. Most agree that it would be better if domestic institutions, whether courts or legislatures, were to initiate the more far-reaching transitional justice measures, perhaps especially those directed at public memory. Some contend that one plausible role for the Inter-American Court and rationale for its decisions is precisely to stimulate such national institutions, to prod them into broad efforts at transitional justice, otherwise domestically too difficult. But that's a political argument in defense of what the court has done. It's not a legal argument. Might the standard theory, as I've described it, of remedies, might it accommodate most of the unprecedented remedies ordered by the Inter-American Court of Human Rights? Might it explain these remedies and justify them in a more prosaic way? I think so, mostly. Leftish critics of the Inter-American Court are too quick to abandon the standard theory, the rightful position test, in favor of a more activist understanding of what it means to judicially redress a wrong, an understanding that sets virtually no limits on what the courts can do. In fact, leading theorists of transitional justice today urge policies aimed so broadly as, quote, to increase trust in discredited government, foster social solidarity among citizens, ensure our universal recognition of all human beings as rights holders, unquote. A few judges on the court themselves actually speak in such sweeping terms. But sticking to the standard theory of judicial remedies, as I've called it, would allow them to defend their decisions in much less controversial terms that maintain the law's doctrinal integrity and political legitimacy. So let's consider the court's new remedies in light of the standard theory. First, injunctions to rehabilitate the memory of victims through mandatory official commemoration and public apology by high-ranking officials. Well, but for the crimes done to them, the plaintiff's reputations would not require recuperation. One major goal of authoritarian regimes is suppressing public knowledge and memory of massive human rights abuse. Media censorship is how autocratic rulers seek to control that process. Censorship is prohibited by the convention that the court enforces, and so efforts to redress censorship's effects serve to advance the rightful position standard. One way to do this is through official commemoration of the state's victims and the naming of public parks and so forth. People often dismiss such remedies as merely symbolic, but symbolic forms of redress may actually be the best means for reaffirming the victim's dignity, which is the legal interest that human rights law most centrally seeks to protect. Symbolic remedies are therefore expressive to the core in the current idiom. And today we widely accept such purely expressive goals as an acceptable aim for civil remedies. And transitional justice studies tell us that victims often regard more material forms with suspicion, sometimes reject material compensation altogether as offensive when it's not accompanied by some meaningful symbolic affirmation of their essential human dignity. So restoring the dignity that they were deprived of helps restore their rightful position. Standard theory. Next, how about requiring the state to consult with victims on how to design these remedial programs, including forms of public commemoration? Well, the main point of all such policies, again, is to make victims whole, and there's clearly a subjective, psychological, emotional element to that. Victims should feel whole as close as possible. Who better than the victims themselves to know how to achieve that? Subject to objective reasonableness, of course. A paradox already emerges here, which is that the remedies most politically controversial, where they've been imposed, turn out to be the ones that are legally least controversial. So in Peru, for instance, lost earnings suffered by victims of the state rights abuse. Many of these victims were apparently active in leftist guerrilla groups of the 70s. So in Peru, the national legislature even enacted a statute precluding their compensation for lost earnings during the period of incarceration, despite an injunction from the Inter-American Court of Human Rights ordering them to compensate these victims. Or orders for standard measures of monetary compensation where many, many victims are involved, so where a total cost of compensating them all would exceed the country's entire gross domestic product, as in one Guatemala case alone. The court steers clear here of political controversy, not because the conventional remedy involves doctrinal novelty, but because the judges want to avoid inviting noncompliance with their orders. By contrast, symbolic remedies, the most legally novel of all, have drawn the least political resistance, if only because they're the least costly in monetary terms. Consider now some other judicial remedies as well, besides the couple I've started with. How about free literacy training, even admission to public universities without fees? Somewhat novel in form, but plausible enough, at least where the surviving victims showed educational promise, so would likely have attended university anyway during the time they were incarcerated. So here we're just making victims whole. What about group remedies to indigenous communities as such? Not only particular members, in other words, dislocated by forced population transfer. Reconstituting a tribal community whose members have scattered, been violently displaced, would just restore the status quo ante, if you could do it. We can't do this by redressing the discrete injuries of particular tribe members, but only by helping to rebuild their collective institutions. So the collectivity is a genuine party and interest in functional terms in such litigation. In these cases, the relevant group also pre-exists the wrong. The group is not an artifact of the litigation itself, as in U.S. tort class actions. Ordering the return of abducted children, still minors, to their birth parents or grandparents as a remedy. That's where they would have been anyway, but for the wrong, so it too is their rightful position. Demanding investigation and prosecution of criminal perpetrators. That would have happened in any event had the authoritarian regime or its successor not wrongfully granted them amnesty or effective impunity in violation of the Convention on Inter-American Convention on Human Rights that's the courts charged with implementing. Rightful position. Judicial orders to change national law, even the country's constitution. Well, the Inter-American Convention on Human Rights itself requires state parties to undertake to adopt, in accordance with their constitutional processes, such legislative measures as may be necessary to give effect to this convention, unquote. The court also correctly invokes here the Vienna Convention on the Law of Treaties, providing that a state's domestic law may not abrogate its duties under international law. And so, where necessary to honor such international legal obligations, domestic law must yield. Judicial orders to invalidate amnesties are therefore lawful under the standard theory. No need to stray beyond it. Locating and exhuming the disappeared. Had the state not disappeared them in the first place, family members would know where they were interred. Rightful position. Orders to return native land wrongfully seized from indigenous populations. Living on those lands would be the status quo ante, and so it would be the standard remedy for the state's internal displacement of tribal peoples. The only novelty here is the further order officially demarcating and titling such land in the name of an indigenous community where it enjoyed no such formal legal ownership before. But that's just to preserve the rightful position, which is what preventive injunctions, as we call them in the common law world, always seek to do. That is, to discourage later efforts to displace the plaintiffs from the rightful position, a danger that otherwise remains strong. Demanding that tenured civil servants implicated in atrocity be removed from public office, lustration, by court order. That as well aims to prevent recurrence of the same wrongs that the court has found. It falls easily under the so-called guarantees of non-recurrence language in the UN General Assembly's basic principles on the right to a remedy. So it too fits the standard theory. Monetary compensation for losing one's proyecto de vida, as it's called, the prejudice that is to the victim's professional potentialities, attaining his realistic ambitions in life. That mostly entails just mid-career vocational training to come up to speed with competent practitioners in one's field. Maybe also what we common lawyers sometimes call hedonic damages, that is losing the pleasure that one otherwise took or would take in favored leisure activities, now impossible due to what one has suffered in captivity. rightful position. State liability for violence by private parties, often criminal gangs, not under the state's effective control? Well, when states ratify the Inter-American Convention, they promise, quote, to ensure all persons subject to their jurisdiction the free and full exercise of those rights and freedoms, unquote, those laid out in the treaty. And so, when states don't show due diligence to that end, they're liable for the consequences, the court plausibly concludes. The remedy here is broad and demanding, yes, but only because the right itself, the legal duty that the states violated, is also very broad, in the language that I quoted. So again, just the rightful position. Restructuring militaries to ensure civilian control by court order. Thank you. Well, these credibly fall under the same language of guarantees of non-repetition under that UN General Assembly resolution I just mentioned on the right to a remedy. And that resolution is expressly invoked by the court, whose statute, like the Inter-American Convention itself, authorizes the court to resort to general international law. These institutional restructurings of police and military forces are simply preventive injunctions, since they spring from the reasonable belief that similar abuse could readily recur without the institutional reforms, such reforms in the near future. For instance, police forces operate under a duty to respect basic civil and political rights. And so when police have recently violated that duty in major ways, an injunction furthering their compliance with it flows naturally from these wrongs, from their nature and extensive scope. Regarding the armed forces, the Inter-American Convention provides a human right to participate in free and fair elections, not a right to live under a regime of civilian supremacy as such, but authoritarian regimes rarely hold free and fair elections, and so judicial measures designed to stave off military rule surely contribute, at least, to protecting honest electoral processes, preventing recurrence of the electoral violations. Slightly beyond the rightful position, admittedly. Then there's, finally, the court's regular attentive monitoring of the state's compliance with increasingly detailed commands over time, when the state shows bad faith, that is. But when the state shows good faith, this court doesn't do that, as in Guatemala. I'm sorry, in the case of Guatemala, the state showed repeated bad faith, and so the court's orders became increasingly more stringent and micromanagement of the remedies. Okay, so the prevention of recurrence goal, again, consistent with the rightful position, that's what's at stake in these efforts to restructure military and armed police forces. So in conclusion, then, the remedial jurisprudence of the Inter-American Court of Human Rights isn't really very radical at all, despite initial appearances. It just applies well-accepted principles to what are simply new fact patterns, novel kinds of wrongdoing. Courts everywhere do that all the time. In theory, at least, courts in Eastern and Central Europe could do the same. Thank you.